All right, John, if you'd like.
Yes, indeed. So welcome everyone to this legal update webinar hosted by the Orange County chapter of IREM. This is John Koss with Anchor Health Properties as your IREM OC VP of Legal Affairs. And I'll be mostly getting out of the way for our two invited experts that have graciously accepted our invitation to speak with us today. Today's topics will focus on situations particular to California. This will range from the update of the commercial tenant eviction process, the residential tenant eviction process, and two propositions on the upcoming California budget, specifically Proposition 15, split roll tax, boo hiss, and Proposition 21, residential rent control, boo hiss. We will have questions afterwards, so please forward your questions to the chat box on your screen, and I will discuss these questions with our speakers at the end of their prepared remarks as time allows. Now for the introductions. Both of our speakers are recognized industry partners of IREM OC. As such, their contact information can be found on the IREM OC website. Susie Lean is a partner at the law firm of Kimball, Thierry, and St. John. She'll be discussing these identified issues from the residential angle. Ellen Tickner is the Director of Client Relations at the law firm of Seide Law, and she will start us off today discussing these identified issues from the commercial angle. And now, I will turn the meeting over to Ellen to get us started.
All righty, give me just a second here to pull up my, here we go. All right, so I'm going to start with just a brief overview of how we ended up where we are right now. So let me just give you a real short version of the background. Obviously, the first thing that happened was a pandemic hit California. Our governor issued a stay-at-home order that effectively shut down all but essential businesses. Non-essential businesses then lost the ability to generate revenue, which resulted in loss of jobs or hours being cut and people having financial difficulties. In response to those financial difficulties, various cities and counties enacted emergency legislation. And let me tell you, they enacted a lot of ordinances. So we have ordinances from tons of cities, then we have counties that enacted ordinances, and they vary greatly, but there were a lot of different things enacted to protect the tenants. After we had about 220 ordinances that I had read and stored, the California Judicial Council amended the California Rules of Court, where they precluded any court in California from issuing a summons on an unlawful detainer action. What that meant effectively is if you can't issue a summons, you don't have a case you can serve. That covered every type of property, residential and commercial, but more importantly, it also covered every type of case. So it covered cases that were non-monetary cases that had nothing to do with COVID, and it covered monetary cases where the delinquency started way before the COVID pandemic hit. There was no exception made for anything that wasn't related to COVID. So for about 7 months, we were precluded from filing and prosecuting any unlawful detainer action, which obviously wreaked havoc on both the residential side and the commercial side. Then to top it off, my favorite part was when the court system was shut down. Boo hiss. So we had no courts for 3.5 months, basically. As we're starting to move now into the new transition, I want to make sure that you understand what governs what, because a lot of people have really been confused about this. The California Judicial Council order does one thing and one thing only as it pertains to this particular area of law. It precluded us from filing unlawful detainer actions. It didn't talk about whether you did or didn't assess late fees. It didn't talk about repayment plans. It didn't talk about anything like that. It simply said, you may not file any unlawful detainer case. That was the purpose of this order as it pertains to our industry. The second thing that we have to worry about are the local ordinances, and they're kind of all over the board. The local ordinances enacted by cities, and in some cases, the counties, tell us what you can and can't charge. For instance, are you allowed to charge late fees or not? Can you serve notices or not? And what period of time is allowed for a repayment plan? So it's really important for you to understand that the CJC order did one thing, the local ordinances did another thing. The California Judicial Council decided to remove their mandate against unlawful detainer filings effective September 1. And when that happened, everyone got really excited. It's like, oh, it's lifted, yay, we can evict everyone who didn't pay during this horrible emergency period we've been under. No, that's not necessarily the case. And it's really, really important for you guys to understand what did happen and also what didn't happen. And Susie will talk about the residential side. Please understand what I'm going to talk to you about today only has to do with commercial properties. Susie has a much tougher job than I do because the regulations pertaining to residential are humongous. Ours are actually pretty simple, although they're confusing. So for commercial property only, and we're only dealing with California, the good news is there's no longer a mandate in effect that says you can't file an unlawful detainer case on a commercial property. That's the good news. You can start dealing with your non-paying tenants. The bad news is the local ordinances, many of those are still in effect. So even though you can technically file an unlawful detainer case, that's all the CJC's order did. Go back to the two different governing agencies we have to deal with. Now you have to figure out what city you're dealing with. Then you have to find out if that city has an ordinance or not. So what we've got to look at now is what geographical area are you concerned with and what are the rules there? So moving down, how do you navigate this? Let's start with the courts. With commercial property, every new case that we file has an additional cover sheet that specifies it's commercial property. If you check the box residential, there's another whole set of rules that have to be dealt with that Susie will cover. For our purposes, we check the box commercial and we actually get kind of a free pass at least to get in the door. The second thing that happens is the courts are now requiring, believe it or not, that we supply the court with the date that the property was built. They want to know the age of the property. I honestly think that's really more for Susie's side because I think that's going to have to do with habitability issues. For our side, I'm not really sure why the court would be concerned when a commercial property was built, but we do have to supply it now on every filing. So you'll find that counsel, whether we represent you or some other firm represents you, we're going to be coming back to you on every single case saying when was the property built. Really, really important. Right now in Southern California only, I'm not talking about the rest of the state, we have successfully filed commercial cases in Orange County, LA, San Diego, Riverside, San Bernardino, and Ventura. Those are the 6 counties that we cover. And all 6 of those are accepting commercial unlawful detainer filings. So now let's go back to the local ordinances. And this is as clear as mud, is the way that I've described it. The first thing that you want to do is find out what ordinance covers your particular project. So let's say hypothetically, your property is located in the city of Santa Ana. The first thing we're going to do is find out if the city of Santa Ana has its own ordinance. It does. And then what does that ordinance do? If your particular city doesn't have an ordinance, then you have to go up to the county. Does the county that city is located in have an ordinance? If so, you have to deal with that. If you have a city ordinance and a county ordinance, the ordinance that gives the tenant the most protection is the one that prevails. Like I said, clear as mud. The second thing that you want to do is see if the ordinance is still in effect. A lot of ordinances were enacted back in March and April, and some of them went through May 31st. Many cities extended that protection through July, extended it again through September, but some of them let their ordinances expire. If it hasn't been extended, then we're in a different position. The third thing that's really critical, and this is the one thing, if you hear nothing that I say today but this, you're going to walk away with good information. You have to find out if the ordinance provided a specific time period for repayment. And that's really critical. For instance, in the County of LA ordinance, which covers the unincorporated areas of the County of LA and any city within LA County that doesn't have its own ordinance is automatically covered by the county ordinance. They have a 12-month repayment period. So if you stop and think about it, if the tenant didn't pay you during the emergency period, which we are, for the most part, assuming is March of 2020 through August of 2020. Let's say they didn't pay you March through August. They were current in February, and in September, they sent you September rent. So the only money that they owe you is the money that became due and was not paid during the emergency period. If that's the case, you don't get to start an eviction action against them for that chunk of money that became due and wasn't paid during the emergency period, because that particular ordinance gives them a 12-month repayment period. And there are really substantial penalties if you choose to go around that. So it gets really, really complicated. Now, if you have a tenant that owed you January, February, and March, we could notice them for January and February, but you need to talk to counsel and make sure that you're really, really clear what you can and can't sue for, because these local ordinances are still out there and you want to be really careful. Again, the penalties are pretty substantial. And I'm looking at my time. I'm going to do these last two things really quick. The purpose of today is not to educate you on the whole process, but to give you a little taste of the process. You're welcome to reach out to any of us for more detailed information, like city by city and county by county. So unlawful detainer actions based on non-monetary issues, you're home free, everything's off on that. If you've got a illegal use, you've got somebody selling pot in a no pot city, you've got a violation of an exclusive use provision, you've got somebody who doesn't carry insurance, anything like that, those cases are home free, you're good. And then the last thing, and I know Susie will reiterate this, please understand that the courts were closed for 3.5 months. The court took 100,000 hearings off calendar. All of those are now being reset. Virtually every landlord up and down the state of California has been waiting for 8 months, 6 months maybe, to get unlawful detainer cases filed. So guess what? They're all filing them now, which means your cases are going to take several months longer than they did pre-COVID. And with that happy news, I'm going to turn you over to Susie, who I think is going to give you even more happy news. Right, Susie?
Unmute myself. I'm going to quickly share my screen. Give me 2 seconds. Okay, so I'm going to be talking about what evictions look like now with AB 3088. And just to start off, I just want to make it clear that this is just sort of a legal update and an overview. I've been doing these AB 3088 trainings multiple times a day since AB 3088 passed, and they're at least 2 hours long, and usually clients will want more than one training because it's so complicated. So I'm just giving you like the super abridged version in 15 minutes or less. So because of that, keep in mind that this is not legal advice, it's just an overview. And with that said, I'm gonna give you the snapshot of AB 3088, which applies to your residential tenancies. And here's what's required. You need to send out any tenant in a residential tenancy this COVID notice of tenants' rights disclosure for any tenant that has a balance due from March 1st of this year through August 31st, and it needs to be sent out number 1 on for all of your tenants that have a delinquency during that time period. Your pay or quit notices that you're going to be serving are now 15 court days. They're 15-day notices, And it's not just your regular 15-day notice, it's a brand new AB 3088 15-day notice that has specific language of rights. It also includes a blank declaration, which your tenant can fill out and sign under penalty of perjury and send back to you. And you need to include the amount of rent and separate it out by the date it became due. So you can't put it all in one lump sum. All other financial obligations that are due under the lease, by the way, are treated the same as COVID-19 rent. You may not be able to put them in that 15-day notice to pay rent or quit, but they're then going to have to go into a 15-day notice to perform or quit, which will basically look the same, except it's a different type of notice. And by the way, just to make this all the more confusing, this particular law is retroactive to March 1st of this year. So we have a lot of clients before the pandemic hit in sort of like mid-March, before the lockdown, before everything, where they had already served pay or quit notices because we didn't know all of this was coming, and they filed cases with our firm or other firms. Well, guess what? If they're asking for rent from March 1st going forward, those cases are going to have to be dismissed, and now we're going to have to serve a 15-day notice. So just an FYI, you're going to be starting back to square one on any of those early cases that were filed, which just makes everybody's day. So the first thing I want to point out about AB 3088 is when the rent becomes due now matters. There are two time periods under this law. There's the protected time period, and that's defined as March 1st through August 31st. And then there's the transition time period, which is defined as rent that becomes due from September 1st to January 31st of next year. And keep in mind that you cannot use the same notice for rent that becomes due during the protected time period versus the transition time period. So it's two separate pay or quit notices because there's different disclosure language in each one, just to complicate things even further. I think they tried to make this as complicated as possible when you read through all of this, because there's so much, you know, little niggly things in there that we now need to worry about. The next thing is how much money your tenant makes now potentially matters, but only if you choose to treat high income tenants differently. And before I get into what this means, I just want to tell you flat out, I don't think this is a good idea. This law is already complicated enough. Just treat everybody as a regular income earner and avoid yourself a lot of headaches. But if you are a brave soul and you decide that you want to treat high income tenant earners differently, what that means under AB 3088 is not only can you require that they return a declaration that they've had a COVID hardship, you can actually also require that they provide some type of verification of this COVID-related hardship. And everybody thinks that sounds like a great idea. I want proof. These people make a lot of money. They need to show me that they're really in trouble. But there are penalties associated with getting it wrong, and I'll talk about those in a second. But first, keep in mind that high-income tenants, it's a tenant household that earns at least $100,000. And on top of that, they also have to meet a second threshold. And this is that they have to make 130% of the area median income for where the property is located. So if you have verification already that your tenant is high income because they told you that on the rental application when they applied, then you could potentially require them to sign a declaration and provide proof that they have a COVID-related financial distress. By the way, remember how I just mentioned that there's two different notices for protected rent and then for transition rent, you can't use the same notice? Well, if you're going to pull out those high income tenants and demand verification, you now have another notice that you have to use because it's got high income disclosure in there. So now you've already got four notices. You've got your protected regular income, your protected high income notice, your transition high income notice, your transition regular income notice. It just gets crazy. And the reason why I said probably don't want to go into this whole high income thing, just let it go and take the declaration, is because if you ask for proof that your tenant is high income, then you can get into a lot of trouble. You're not allowed to ask them, well, how much money do you make? You have to use the information that you already have on hand. And unfortunately, if one of your managers makes a mistake and asks for verification of how much money they make, when you file the unlawful detainer, your tenant can use that against you, and the judge can find in favor of your tenant, and guess what? You might have to pay their attorney's fees. So like I said, it's just not worth it. It's too complicated. Just take the declaration and be done with it. And I'll talk about other reasons why, but just to simplify a very complicated situation, this is one of those things you could take out of the equation to make this a little bit more doable. So then just quickly, remember I talked about protected rent, transition rent. This is just a quick little summary of why these are different and why the distinction matters. Like I said, protected rent is March 1st through August 31st. Any money that your tenant hasn't paid during that time period. Remember, we serve a 15-day pay or quit notice. It's got special protected rent disclosure language in there. It's also got a declaration that your tenant can sign and return to you under penalty of perjury. Hey, I have a COVID financial hardship. If they return that declaration back to you, you are never going to be able to evict them for that rent from March 1st through August 31st. Never, ever. It's just completely off the table now. And what happens is that rent, that big chunk of rent, gets turned into consumer debt, and now you're going to have to go after them in small claims court. And by the way, part of AB 3088, they amended the small claims statutes in California, so you're no longer capped at a certain amount. You can ask for the total amount of COVID debt that they owe you from March 1st through August 31st, so that's a good thing. You can file as many actions as you need to. There's no cap on the number of small claims actions. If you need to file 100, you can. And also keep in mind too that this isn't a total loss, because you're going to get a judgment, a money judgment in small claims. It's good for 10 years. It can be renewed for another 10. The tenant's going to be charged interest that whole time that they're not paying. So they're going to have to pay the piper sooner or later. You know, they're not getting out of this scot-free. The only difference is we can't evict them for rent from March 1st through August 31st. And by the way, you serve your notice, they don't pay, you serve the notice, they don't pay, they don't return a declaration, you can actually file the eviction as of October 5th. So you don't have to wait. You can file the eviction as soon as October 5th if they do not return any declaration. But that is the key. And for all of you supervisors on this call, you are going to want to double and triple check with your on-site staff to make sure they did not return any declaration, whether it was written in crayon, it was on some type of sandstone. We don't care. We want to know if they gave some type of declaration so we can take a look at it. So now let's move on. We served that notice. It's all going to small claims. Now we're on to this transition rent, and this is from September 1st through January 31st. Now the way that AB 38 is written is the tenant is supposed to pay 25% of the rent in order to avoid eviction during this quote unquote transition period. But this is very misleading, because in all actuality, your tenant does not have to pay that 25% for all those months until the very last day, which is on January 31st, 2021. So they can return a declaration, then you're gonna have to wait until January 31st of 2021 to see if they make good on the 25%. If they do, then they are actually protected from being evicted for rent from September 1st through January 31st. And that 75% amount that they didn't pay you yet, that's going to small claims too. And you're never gonna be able to evict them for that. If you serve them a notice, they return a declaration, and they don't pay the 25% by January 31st, you can actually evict them on February 1st for that unpaid rent. And again, if you serve a notice and they don't return anything, no declaration, nothing, then you can file an eviction as soon as October 5th. Complicated enough for you? It's crazy. But I will say there's also a prohibition against serving other types of no-cause notices. So you don't get to serve your notice of non-renewal anymore or your 60-day notice. You just want to get rid of somebody, their lease is expiring. Guess what? You don't get to do that under AB 3088. You have to have a just cause reason in order to serve a termination notice, such as breach of lease, nuisance, criminal activity, failure to allow access, subletting if it's not allowed under the lease. It's all of those things that are defined under AB 1482, which also just passed this year. They're using that definition in AB 1482 to talk about just cause. So if you've already served like a 60-day notice or a notice of non-renewal, and it's just sitting out there and it hasn't expired yet, you're gonna wanna claw those notices back and go for Plan B, because you're not gonna be able to file on them. And by the way, this applies to every tenancy. Single family home, new construction, affordable, everybody's covered under this just cause requirement under 3088. Even if you're not subject to 1482 prior to 3088 because your building's only 2 years old. Well, now you're still gonna have to have just cause to evict somebody under 3088. Okay, we quickly want to talk about the added headache to this whole situation here. So AB 3088 was actually enacted on August 31st. This was like a rush job by the legislature. They were running out of time. They wanted to get something done as quickly as possible because the Judicial Council lifted Rule 1. And so they slapped this bad boy together really quickly, which is probably why it's so complicated. And 2 days later, on September 2nd, we hear that the CDC has enacted this nationwide eviction moratorium. And everyone's thinking, what? How does that fit into all of this? And so then our governor, our handsome governor, goes on the news and he says, oh, that doesn't apply in California. We've got AB 3088. We're all good here. We don't need this CDC stuff because our eviction moratorium under AB 3088 is more protective. Well, that's not necessarily true. And I really don't think Governor Newsom is going to pay that $500,000 fine you're going to get if you violate the nationwide CDC moratorium. So I think all of us landlords at this point have to dig into that a little bit deeper for our own protection. It's unfortunate because things are complicated enough. Now we need to kind of look and see, well, how does the CDC moratorium impact me? So number one, keep in mind that there is no deadline for returning a CDC declaration to a landlord. You can do it the day before the lockout. And we're having that right now, folks, by the way. These cases that are currently going through the system, everybody's got their CDC declarations that they're turning in. And the moratorium doesn't expire until December 31st. So keep that in mind. And I will also tell you, you can just bet that every legal aid, every tenants' rights group attorney, they're all gonna be in court with a stack of blank CDC declarations that they're gonna be passing out like candy to everybody. And so when your tenant goes to court, they're gonna be like, oh, here's my declaration. And if it's not a case that falls outside the protection of the CDC, then you're probably gonna see judges that are gonna refuse to go forward on that case until after December 31st. Again, we're already starting to see that now with these cases that are that were jammed up in the system when everything shut down because of Rule 1. So you just need to know that this is out there. AB 3088 is a challenge to understand, and we all need to become experts on it because it applies to us, but we also need to all understand the CDC eviction moratorium and how that plays out with all of this as well, because we do think it applies in California, because there are areas where the CDC moratorium is more protective than AB 3088, unfortunately. So it's kind of looking at both. That's it in a nutshell. We were really hoping that we would get some type of official, like federal waiver, so that this would not be an issue. We thought that that was going to happen just based on the press conference and everything, and I don't think that's happening now. So I think this is something that we're going to have to deal with until December 31st when it expires. I love this, by the way. One of my colleagues sent me this picture, and it's just so fitting. Okay, I'm going to pass this over to Ellen. I'm stopping my screen share.
So now we'll go into discussing some propositions that are in the news.
You know, Olivia, when you named this seminar and called it legal updates and stuff, I think maybe you should have nicknamed it Doom and Gloom, because I thought I was being the bearer of bad tidings, but I'm feeling pretty positive after listening to Susie. She definitely got the short straw here.
Yeah, I'm
So
getting
let's
a lot
talk
of
about some.
tomatoes thrown at me.
I'm sorry.
I said I've been getting a lot of tomatoes thrown at me recently.
Yeah, I bet you have, and I feel bad about that because you're a nice person. So let's talk about Prop 15. Boo, hiss. Real quick overview. Years and years and years ago, back before you know, there were automobiles and running water and electricity, Prop 13 was passed. And Prop 13, the purpose of that was to give protection to homeowners and limit the amount, the percentage amount that your taxes could increase in any given year. And it was to make sure that you knew you had a finite expense. You knew what your max was going to be, and you could therefore plan your budget, you know, minor detail. So there, at the risk of being politically inappropriate here, the more liberal side of our state has been trying to eliminate the Prop 13 protection for years. And normally they don't really get anywhere, but now that we have what I call a supermajority on steroids in Sacramento, Prop 15 is out there, and they have a really good chance of pulling this off. So we're trying to educate our members, and feel free to take the handout that I'm giving you guys, which hopefully Olivia will put up before we close today, that you can pass this on to all of your friends. Anyone and everyone needs to understand what Prop 15 really does. Prop 15, also known as the split roll, takes the tax roll and splits it in half between the commercial real estate and the residential real estate. So the homeowners go, great, it has nothing to do with me. It's those big, bad, greedy commercial landlords who are wealthy and greedy and blankety, blankety, blank, you know, fill in the blanks. They're the ones that are going to take, you know, the Amazons of the world and the Disney, you know, they're going to take this tax hit. Me as a homeowner, I'm not going to be impacted. And that is a selling point for the proponents of Prop 15. Selling point number one, it's not about the homeowner. It's about those really wealthy commercial property owners, because we know every commercial property owner is wealthy, right? The second thing that they say is that this money is earmarked for our children and for the hardworking teachers out there. Now, don't get me wrong, I'm a mom and I love and respect teachers, but we've heard this story kind of a lot over the decades. Oh, the gas tax, that was going to make life work for our school system, okay? And then the lottery, you know, the lotto, that was going to take care of our students, okay? And what we find is these huge tax revenues hit, and where does the money go? It's not going to take care of our lovely children and their hardworking teachers. It goes into the general fund, and it goes wherever the people up there want it to go, depending on who's power in a given year. So it's not about the children. Okay, it really isn't about the children. It's another excuse to tax the heck out of us. So that's number two. Number three, you have to stop and think about the way government works. Have you ever seen the government open Pandora's box to take a bite and say, well, we only took one bite and we promised we wouldn't go any further, so we're good people and we're not going to go any further? No, it doesn't work like that. If you take away Prop 13 protection from commercial properties, trust me, residential property will be next. And that's really, really scary. But let's take it a step further. People are saying this isn't going to impact the homeowner. As long as you don't own commercial real estate, it's not going to impact you at all. So don't worry about it. Okay, let's talk about what a triple net lease is. A triple net lease, you have your base rent, and then the net is typically insurance, taxes, and common area maintenance expenses. Not every lease in California is a triple net lease, but a very large majority of them are. So what that means is any increase in the landlord's taxes or insurance premiums or common area maintenance expenses, any increase in those numbers gets passed on to who? Trickle down, the tenants. So let's say as a law firm, and we have our offices, and Prop 15 passes, and our landlord's tax hit quadruples. He will then pass on our pro rata share of that to us as a law firm. And what will we do? Trickle down. We will then increase our hourly rate to make more revenue in order to be able to pay our higher rent to the landlord who's having to pay higher taxes. Trickle down. So what you need to understand is if Prop 15 passes, you as a consumer and a homeowner, will it impact you? Heck yes, it'll impact you. Every single product you buy and every single service you use is going to get more expensive. If Vons or Safeway or Costco, if their rent goes up exponentially because of the tax hit, what are they going to do with the products? Increase the prices. What about services? Your doctor, your veterinarian, the company that takes care of your landscaping, any service that you use, the little guy that repairs something, your car, you take your car in for service. If the automobile dealership, if their rent increases dramatically because of the tax hit, what do you think they're going to do with the cost of service? It's going to increase. So you as a homeowner or as a renter who's a consumer in California will be impacted, and you'll be impacted very dramatically. Every single good, every single service will cost more money. The other thing that's going to happen is that it's going to impact the Amazons of the world will do just fine. But we have gazillions of small businesses out there, and a lot of the small businesses are women-owned, minority-owned, veteran-owned businesses. The little guys that are out there aren't going to be able to afford that tax hit. We're going to lose a lot of small businesses. And gosh, aren't we in a pandemic right now? The timing of Prop 15 could not be worse. We should be doing anything and everything we can do in this state to keep small businesses alive and help them survive. What you don't want to do in the middle of a pandemic is say, hey, you're struggling, you're barely surviving. Guess what? We're going to nail you with a huge tax increase because we love you and we want to keep you in California. I mean, it just doesn't make sense. So you're going to have businesses leaving the state, or you're going to have businesses going under. And that means more job losses. So the only thing I can say in summary is vote no on Prop 15. It is a nasty, scary bill. And on that note, let's see if Susie can talk more about rent control, because that's a fun topic.
There we go. had to unmute myself. So Prop 21, this is also going to be on the ballot. If you remember from 2018 when we had Prop 10, this is almost identical to Prop 10, which was defeated. And it's all about rent control. And basically, in a nutshell, what Prop 21 is going to do is repeal Costa-Hawkins. And most people are like, well, what the heck is that? What does that mean? Well, Costa-Hawkins is a separate law in California that was enacted back in 1995 in response to a lot of local jurisdictions like the crazy San Franciscos and Berkeleys of the world that had passed the most onerous forms of rent control. And the biggie for that would be that they were implementing vacancy control, which means like when you have a tenant that is living at your property in a rent controlled property now, and the tenant moves out, the landlord gets to reset that rent back up to market. And then when the new tenant moves in, the rent is controlled for that tenancy all the way through while that person lives there, but then they move out and the landlord gets to reset the rent again to market. So vacancy decontrol is what that's called, when you get to decontrol the rent cap when you have a new tenant move in. And that's what allows a lot of, all landlords in these rent control jurisdictions to stay in business. They're okay that the rent is capped while the tenant is in there, but then the tenant moves out and they can raise the rent to market. Well, really what Prop 21 seeks to do is to repeal Costa-Hawkins so that local ordinances can implement vacancy controls. So when you have somebody move out, guess what? When the next tenant is going to be moving into that unit, they've basically won the lottery, because that unit's rent cannot be raised to market. There's going to be a cap on how much you can raise the rent. And by the way, it's just whoever applies for that unit. It's not for people who are low income or seniors or veterans. The luckiest person that shows up and gets that unit, they get the benefit of that lower rent. The other problem is Costa-Hawkins prevents rent control for single family homes and for properties built after 1995. Well, Prop 21 seeks to do away with that so that, single family homes can be rent controlled and newer properties can also be under rent control. And by the way, keep in mind that in California right now, there is nothing stopping a city from passing rent control. Cities have the right to do that right now with Costa-Hawkins in place, but it keeps the type of rent control they pass in check, and that's the difference. And so it's all of the apartment industries, all of the large residential and small mom and pop landlords are fighting this Prop 21 to try to make sure that, it's one thing to have a city pass rent control. It's another thing when they take away or when they implement vacancy controls and when they start to rent control newer properties and single family homes. So those are the main issues associated with this. There's a website on the bottom. It's the noonprop21.vote website. I looked at it and there's a lot of great information, most of which I don't have time to go into now, but I just hit the highlights for you. So hopefully we're going to be able to defeat this one along with our split roll.
So thank you very much, both of you. I didn't get many people writing questions for our group chat. So please send it to me if you have some, but I do have some questions. First of all, for Ellen, there's a lot of revised notices, the 4 notices that Susie was talking about for residential. How many different notices are there in commercial? Is it still just a singular notice, or is it the multiple guest one that Susie was talking about?
That's a good question. And the bad news is Susie's life has just become the opposite of heaven. For us on commercial property, we don't have multiple notices. Our rules are much easier. We are using the same notices that we have always used, which are, either a 3-day, or if your lease requires some other time period, they are business day notices as opposed to calendar day notices these days. But we're actually able to use pretty much the same notice forms. The only real requirement for us is when the notice period expires and we actually are going to file the lawsuit, there's a new civil cover sheet that we have to add to the package. But other than that, that part is really pretty simple for us. Our detail work is just looking at all the local ordinances to make sure that we don't do anything wrong that would subject our client to a severe financial penalty. It's a really good question, but no, we're off the hook.
So then our next question is for Susie. Do you find, Ellen was talking about all the different city and county ordinances. In addition to what AB 3088, are there additional hurdles, if you will? You were talking about Santa Ana, but are there additional hurdles that are you have to consider?
Oh yeah, I kind of focused on in my limited time just the complexity of AB 3088 and then mentioned the CDC eviction moratorium, but you're absolutely right. There are still a lot of local ordinances out there that have not expired that affect residential landlords. Some of them are way more protective than AB 3088, such as the city of Los Angeles, where you really can't do much of anything and you're not going to be able to until next March. So that's the very first place that you look is, what am I allowed to do under my local ordinance? Has it expired yet? And then the tenant is going to get the benefit of the greater protection between the two.
Thank you. And then I was on a no on Proposition 15 call this morning. And it was very interesting on a couple things that suppose California teachers are a big backer, TA, League of Women Voters, our governor, but also it's very interesting that Facebook is a very big donor to this movement. And yet they're moving their new operations to Nashville outside of California. So I thought that was very disingenuous. Their ads are supposed to be hitting in the end of September. And so you'll be seeing, hopefully, signs and such. And we'll put information up on the IREM OC website legal tab for the no on Proposition 15, the no on Proposition 21, and many other things. I'll open it back up to you. I still don't have getting, maybe Olivia, I'm not getting the chat questions, but they are pretty few in such. If you have a question, please dial it in because we have time to talk about it. But I will give you time.
John, can I add something about Los Angeles? Yes. Just to clarify, there's the city of LA proper, which is one ordinance that, and as John said, it's pretty nasty, and Susie said the same thing. But the other one you really, really want to be careful about it and watch is the one enacted by the County of Los Angeles, because a lot of people don't realize if the city in LA County that you are in does not have its own ordinance, you are automatically now governed by the County of LA ordinance. And it's another nasty one. But there are a lot of people out there that think, well, city of industry, we don't have an ordinance, I'm home free. No, you're not. You're covered by the county. So it's really, really critical if you're anywhere in LA County that you make sure to familiarize yourself with the ordinances put out by the County of LA so that you don't end up getting caught up short. Sorry to interrupt, John.
No, that's great. Susie, do you have anything else you want to add in?
No, I just saw a question on the chat that was asking, is it true that the governor came out against Prop 21? And yes, that is true. So I don't know how much that'll make a difference, but we'll take every no on Prop 21 we can get.
And how kind of him. He came out in favor of Prop 15 split roll.
Oh.
I know, go figure.
So one other thing I want to make note while we still have many people on the call, Still make your nominations for annual awards for the IREM Orange County Awards. We're still accepting awards, and there's for people, buildings, etc. Olivia is going to quickly bring up the slide, I guess, to our end of the year winners and such. So the deadline's coming up, but it's still wide open. So please nominate as you can. Thank you. Any closing comments? I think we're about due
Oh,
an hour coming up here.
I'm gonna quickly put my screen up just for the ease of providing contact information in case anybody needs to reach out to either one of us. So just putting that up there really quickly.
And again, you can look into our Orange County website so that and industry partners, and it's there as well.
Just wanted to say thank you to John and Olivia and Stephanie for putting this together, and Gary for putting this together, giving us the opportunity to visit with you guys today. I know it's a lot of work when you guys put something like this together. So on behalf of our firm, and I'm sure Susie's, thank you so much.
And we want to thank you both, Ellen and Susie. A virtual clapping. Thank you very much. Applause for great information. And as Olivia said, we'll make it available for everyone who wasn't able to scribble down all the notes that they wanted to scribble down today. So thank you very much, and good day to everybody. Thank you.
Take care.